Good day, Crime Talk aficionados. The world's top golfer, a guy by the name of Scottie Scheffler, was arrested on charges of assaulting a peace officer at the PGA Championship event this morning. Now, the defense begins the defense of Chad Daybell starting Monday morning, and we have a story about a teenager who shot his parents because he was upset about their upbringing. We have a quick update on the Karen Reed trial and our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below and hit that little bell for notifications. All right, before we get started today, hope you all have a wonderful weekend, and we will bring the Chad Daybell trial, which resumes on Monday, to you right here on Crime Talk. All right, let's go ahead and open the record for May 17th, 2024, and let's get to our top stories. And the top story today is top golfer Scottie Scheffler charged with assaulting a police officer. So let's just give you my biases right out of the picture, all right? I still follow golf. The reason I truly followed golf was because my son played junior golf. He played high school golf, and he played in college. My son was in the state for a championship, I think 3 of his 4 years in high school, and he was a runner-up twice to a kid by the name of Wyndham Clark. Yeah, the kid that won the U.S. Open last year. So I follow golf because of that reason. My son played with a lot of these kids that are winning now on the PGA Tour. And there's another kid that my son played with at the Air Force Academy who's on the PGA Tour, a kid by the name of Kyle Westmoreland. And I say kids, they're young men. They're 29, 30 years old now, but they're still kids to me because, well, that's when I met them. Anyway, so Scottie Scheffler, all right? This guy is probably one of the most humble guys on the PGA Tour. His wife was pregnant when he was playing at the Masters tournament a couple of weeks ago. And he was asked, what would happen if your wife gave you the call that she was going into labor? And he said, I will leave immediately, even if I'm winning. Well, he wound up winning, and I think he's won like 6 of the last 7 tournaments, or 7 of all 7 tournaments that he's entered. That's how good this guy is. Most humble guy in the world, all right? Well, he got arrested early this morning and charged with felony assault on a peace officer and, let's throw in a little reckless driving, outside of the PGA Championship, which is in Louisville, Kentucky this week. Now, Mr. Scheffler was detained after he was seen driving on a median towards the entrance of the Valhalla Golf Club, the site of the event, and initially failing to heed an officer's order for him to stop. Now, this is all according to an ESPN reporter who witnessed the entire incident. So here we go. At the time of this all taking place, there apparently was a traffic outside the entrance, and it was being rerouted after a man had been hit and killed by a shuttle bus earlier in the day. This was causing all of the backup in traffic. So the players were trying to get to the club so they could begin their routine. So anyway, according to the police report, it alleges that about 6:16 a.m., Scheffler swerved into opposing traffic lanes to avoid the backed up traffic and gained access to the golf course, or attempted to do so. Apparently, there was an officer there. He was wearing his uniform. So the officer then stopped Scheffler and tried to give him some instructions. But apparently there was some confusion or misunderstanding, or he refused. That is yet to be determined. Anyway, Mr. Scheffler then drove off. The cop then somehow attached himself to the car, and after about 10 to 15 feet, the car stopped. That's when the police department says that the officer suffered pain and swelling and an abrasion to his left wrist and knee and was taken to a local area hospital. Now, according to the detective's notes, this officer, the uniform pants valued at approximately $80 were damaged beyond repair. And shortly before his scheduled tee time on Friday, Scheffler, in a statement, described the incident as a result of a big misunderstanding. He said, quote, "This morning I was proceeding as directed by police officers. It was a very chaotic situation, understandably so considering the tragic accident that had occurred earlier." Scheffler said in the post that there was a big misunderstanding of what I thought I was being asked to do. I never intended to disregard any of the instructions. I am hopeful to put this to the side and focus on golf today. Well, here's a picture. Mr. Scheffler's booked into evidence, and he was originally charged with second-degree assault on a peace officer, a felony, as well as third-degree misdemeanor criminal mischief, reckless driving, and disregarding a traffic signal from an officer directing traffic. Anyway, Scheffler was released at about 9 a.m. this morning, and he made his tee time for this morning as well. The attorney for Mr. Scheffler stated that he was driving to the golf course to start his pre-round preparations and proceeded as directed by another traffic officer. Now, due to the combination of events and traffic and a fatality, it was somewhat chaotic, according to Scheffler's attorney. And in the confusion, Scottie is alleged to have disregarded a traffic officer's signal, resulting in these charges. And he said that multiple eyewitnesses have confirmed that he, referring to Scheffler, did not do anything wrong, but was simply proceeded as directed. He stopped immediately upon being directed to and never at any point assaulted a police officer. Obviously, the assault is having the car allegedly drag him that the officer apparently got onto. Anyway, like I said, Scheffler made his 10:08 tee time that was departing from the 10th hole today, and he arrived at Valhalla about 9:10, only 10 minutes after being released, and had less than an hour to prepare. Like I said, this guy's got super focus. I bet he wins the tournament. I really hope he does. Now, here's a video from an ESPN reporter, a guy by the name of Jeff Darlington, who said that he saw the whole incident and saw that Scheffler was detained by police, and he was being placed in the back of the police vehicle as he tried to pull around what he believed to be was a security guard. The reporter stated that when he didn't stop, the police officer attached himself to the car. Scheffler then traveled about another 10 yards before stopping, and that's when the police officer then grabbed his arm, attempting to pull him out of the car. Scheffler opened the door, at which point the officer pulled him out and pushed him up against the car and immediately placed him into handcuffs. Now, there are some memes going around on Twitter today that are actually quite funny, where they have the mugshot of Tiger Woods, John Daly, and now Mr. Scheffler saying, "Welcome to the club." Now, obviously, don't take light of anybody getting prosecuted. I think this will probably be determined to be a misunderstanding, and Mr. Scheffler can certainly write this officer a check for his $80 work pants that was ruined, apparently, by being dragged. I'm sure he'll cover any medical bills as well. I don't see Mr. Scheffler ever getting a felony out of this, perhaps a traffic violation at most. I hope. And like I said, I'm biased on this one. Scheffler all the way. All right. Next on the docket, the Chad Daybell case. Well, yesterday's resting of the government we thought was going to be some dramatic news. It turned out to be a complete dud. Now, a lot of people think that I am wrong about my analysis yesterday, okay? And it frankly doesn't really matter at this point. And let's be clear. I think Chad Daybell is going to be found guilty. My whole point is this was prosecutorial malpractice, what took place, okay? And like I said, I've been doing some seriously thinking. I tried to do a little research about this. Nowhere in all the places that I have practiced, all right, does the prosecutor have to ask for permission to amend their indictment. They just go do it. They go do a superseding or they get an amended indictment, and that's just the way it takes place. So I'm thinking there must be a couple of things. Either one, they put the judiciary somewhat in charge because young prosecutors were screwing something up, or somebody was abusing the process, and so therefore they put in this check by having the court to do it. Never seen anyone have to ask the court to amend an indictment. U.S. attorneys do it all the time. They just go do it. State prosecutors, they just do it all the time. Judge, we're going to go indict. Because remember, they're supposed to be secret proceedings. So here was my beef about what took place yesterday. This wasn't just a little typo, all right? The prosecution apparently in Idaho asked for permission. They say we're going to amend these charges. So they go to the grand jury. They present all this information to the grand jury. And then they file an amended indictment, which is like an amended complaint. Show me anywhere other than Idaho where an amended or superseding indictment complaint doesn't supersede replace the one that came before it. Unless you're in Idaho, of course, and it says, well, unless, of course, we got it wrong, okay? Never seen anything like it, okay? And I have practiced, obviously, stayed here in Colorado. I've practiced in federal courts. I practiced in 7 different states in federal courts. So that's Colorado, Wyoming, South Dakota, Oklahoma, New Mexico, South Carolina, and North Carolina. Never seen an indictment done that way. Never seen anything where it says, well, why would the superseding indictment not be the controlling document? Okay? So maybe I am the ignorant one, and hey, it's just a little typographical error, and, bygones, no big deal. I think it's just absolute sloppiness, and hey, I get it, things happen, things get busy, but the prosecution has had 4 years to prepare this case. They filed an amended indictment per their request. Why is that not the controlling document? All right? And what this has proved to me is that, like I said, if there are no rules and the rules aren't meant to be followed, what does it matter? And if the prosecution can always do whatever they want, whenever they want to do it, what does it matter? Hell, why even give them an indictment? Why even give them a date, apparently? You don't even have to give a date, according to the prosecutors yesterday. Show me one complaint and information in a felony case or an indictment that doesn't have the date of the crime. They blew it, okay? And what's really tragic, I think, about yesterday was the judge was going to toss that count 4. And not that I want Chad Daybell to get away with it. And frankly, it wouldn't have mattered because there was still the conspiracy count in count 3 that the prosecution's amended or asked for permission to amend, all right? What was so disappointing was the judge knew that that was the right thing to do. The people had rested. That was the controlling document. Everybody knows it. And then he asked the prosecution, I'm going to give you 2 hours. Just give me any reason to let me help you out here. Give me any reason. So they come up with it and say, well, we asked for permission, but we didn't amend that one, even though it's amended in the actual document that we should all be relying upon. Remember the document that we read to the jury? But judge, don't worry about that. Or dates don't matter. Or just let us reopen the case. And we'll see if that's actually what takes place, because the judge also says, well, now you got me this far. Now what do I do? Okay? It's legal gymnastics to get to the result that he wanted. This is my pet peeve, ladies and gentlemen. In the legal community, the law is supposed to be applied to all the same. The rules are set, and they're to be followed. These are the facts. These are the rules. If the facts and the rules don't give you the result you don't like, well, that's the law. And the law is supposed to be done with interpreted and decisions made with neither passion nor prejudice whatsoever. And so I think what this totally proved yesterday is what we've always thought all along. Judge Boyce is a complete hack, okay? I get it. You can say it's the right thing to do. Oh, it's a Scrivener's error. No, a Scrivener's error is when a minute order is done and they put the 15th instead of the 16th. That's what a clerical error is, not something on a major document on a death penalty case. The prosecutors were completely incompetent. They committed legal malpractice, and of course, no one's going to hold them accountable. The judge didn't. Who's going to do it? This was the elected DA. These are high up muckety-mucks in the Attorney General's office. You think anyone's going to say, ooh, on your next evaluation, wow, you really almost screwed the pooch on this one, didn't you? No big deal. And that's why prosecutors will continue to be lazy. They'll be sloppy because the judges bail them out. And I had a conversation a while back with a county court judge. And county court judges always think it's kind of their duty to help train the young prosecutors and the young public defenders. And he asked me, well, do you think I'm doing the right job? And I said, no, I think it's absolutely, you're doing an injustice to them, because when you bail them out of those situations, then they don't learn from it. All right. They learn from it when they got to go talk to that family member and say, I messed up. I didn't have the right witness. I charged the wrong date. I wasn't thorough in my preparation. And same thing with the young public defenders as well. You learn more when you lose or you get slapped down than you do when everything always goes your way. Anyway, that's all I'm going to say about it. It's done. I know some people don't agree with me. That's fine. We can have the debate. I've tried to respond to many of you in the comment sections. Like I said, it's not a typo. It wasn't a typo. It's an amended indictment in a freaking death penalty case. And if you can't rely upon that document, it just doesn't matter. I'm telling you, it just shows you. I don't know. This is why some days I get cynical and you think everything's rigged. Everybody lies. It doesn't matter. They're just going to get to the result they want. And if the law doesn't matter, like I said, we're no different. And if the rules don't apply, we're no different than some little communist country where we just do whatever the hell we want. Anyway, on to different news. Hey, let's talk about that teen that shot his parents because he didn't really like his upbringing. Please meet Jeremiah Blair. He's 19, and now he faces 2 counts of attempted murder in connection to the shooting that happened Monday in a neighborhood in Chandler, Arizona. Now, officers were first called out to the home about 5:30 a.m. after the mother told 911 that, she and her husband had been shot by their son. When the police arrived shortly thereafter, Mr. Blair reportedly was waiting for officers in the driveway and surrendered without incident. Now, court records detailing what was said, apparently Mr. Blair had made many statements about this day coming before pointing and shooting a 9mm handgun at both his parents. Once in police custody, Mr. Blair admitted to what had happened, explaining that he had been upset over his upbringing and that he was not treated as he should have been as a child. Now, other court records say that he had been planning to kill his parents for years, and he had been hiding the gun in his bedroom closet. Now, Mr. Blair allegedly said that he had taken the gun out of his room so that he could shoot and kill both of his parents, and that he thought of ways to kill his parents and believed that a handgun would be the most effective. The court records also state that he first planned to kill his parents on Mother's Day, but changed his mind and set his plan in motion just after midnight early Monday morning. And according to further statements, he placed the gun and a video camera in the kitchen around 1 a.m. and waited for his parents to get up and get ready to go to work, telling detectives that he wanted to record the incident. Apparently, as the father came down, he told him that he knew this day was coming and admitted to the shooting. He then ran upstairs and shot his mom once after he came out of the bedroom. Now, while Mr. Blair waited for the police to arrive, he had been upset that he did not kill one parent, but was happy believing he had killed the other. Police said that both parents were hospitalized and in stable conditions, and they each required surgery. Mr. Blair said that he told the police that he knew what he had done was wrong. Well, now, Mr. Blair faces 2 counts of first-degree attempted murder. He is also in the Maricopa County Jail for $750,000. Well, obviously, what needs to take place here, ladies and gentlemen, is the parents need to be charged as well, right? They have this still teenager living in their house, plotting their deaths, and they didn't know what was going on. There's no information of whether they bought the gun or he bought it himself, but does it really matter? They are the parents under this household. They should have known. Come on, just like the Crumleys. All we just need is a young prosecutor to take this case up and let's do it. And it's no longer novel. Somebody else has been convicted of it. How could these parents not have known that their son was in their own house plotting to kill them for years? What kind of bad parenting was taking place there, ladies and gentlemen? They're not the victims here. Oh, no, no, no. They should be the defendants. Okay, and for those of you who don't know sarcasm, that was sarcasm, all right? But once again, it just shows you how when you do ridiculous prosecutions that this is the way people start to think. And I'm telling you, it's coming to a neighborhood near you. I just hope it's not any of you, ladies and gentlemen. Next, Karen Reed, the trial that should have lasted a week. Well, we're in day 14. But yesterday, on day 13 in the Karen Reed trial, it apparently got a little exciting. So Matthew McCabe testified that he woke up to someone screaming the morning of January 29th of 2022. Now remember, Mr. McCabe is a key witness in the trial that's taking place there in Massachusetts. Now, Mr. McCabe is the husband of Jennifer McCabe, McCabe, one of the three women who flagged down the Canton police officer, Stephen Saraf, about 6 a.m. on January 29th, outside of the O'Keefe residence where the body was found. Jennifer McCabe was joined by Carrie Roberts and Reed herself, other local officers, and the Canton Fire Department paramedics who testified in the first week would come soon after. Ms. Karen Reed faces charges of second-degree murder, motor vehicle manslaughter, and leaving the scene of a collision causing the death of Mr. O'Keefe, her boyfriend, who just happened to be a Boston police officer when he died. And that's the big question. How did he die? Prosecutors say that after a night out drinking, the pair argued and Miss Reed, killed Mr. O'Keefe by backing Lexus SUV into him at a high speed, leaving him to die in the cold with major injuries in a snowstorm. Well, an FBI examiner has found that Jennifer McCabe made a Google search of how long to die in the cold just before Mr. O'Keefe's body was found. Now, the defense has developed a third-party killer theory and has alleged that there was a massive cover-up by these police officers to ensnare their client, Miss Reed. So Colin Albert, he was then a senior in high school. He appeared with bruised and cut-up knuckles weeks later. And then Brian Albert, Colin's uncle, who at the time owned the 34 Fairview Road with his wife Nicole, and Brian Higgins, a friend of Albert's who allegedly had a romantic connection with Reed, are the three in the defense has identified in their theory. Now, Colin and Brian Albert have testified they did not see O'Keefe enter the home that night. Higgins has yet to be called to the stand. So on Thursday, Matthew McCabe testified that he and his wife went out to Canton's Waterfall Bar and Grill for drinks, and the socialization began there for drinks and socialization the night of January 28th of 2022. There, they met O'Keefe, Reed, and Christopher and Julia Albert, Colin's parents, as well as some others. Mr. McCabe recollected the demeanor being happy and normal at the Fairview Road address, where he and the others would later go that night for a celebratory drink for Brian Albert's 23rd birthday. Well, an SUV in front of the home caught McCabe's attention from outside the room, he said, as Reed and O'Keefe had yet to come inside. What the hell are they doing? McCabe thought. At the time, he recalled, we didn't know where they were. Anyway, McCabe and his wife would leave the home around 1:45 a.m. with Julie Nagel and Sarah Levinson's friends of Brian Albert's, who had been there celebrating the party. Nagel on Tuesday testified that she saw something out of the ordinary, like a black bob on the front lawn while leaving the home, and she described the object as 5 or 6 feet long, but it didn't raise immediate concerns. Now, McCabe said Thursday that he didn't notice anything as his eyes were focused on the road with the snow starting to build up. So the plot thickens, ladies and gentlemen. Obviously, Miss Reed saying, hey, I dropped off O'Keefe. He goes inside. He has dog bites on his hand. He has bruises. Couldn't have been caused by me. Obviously, the people in the house beat him up, killed him, or he died some way. They put him out front, accusing Miss Karen Reed of backing over him, killing him. This is what we call a question of fact, right? Judges rule on questions of law. Is this a legal question? Is this legal evidence to come in? Juries decide who's telling the truth. Juries decide what happened. Did he go inside, die, get dumped outside, or did Miss Reed back over him and kill him? We'll see if the prosecution can prove their case unanimously to 12 individuals. And finally today, our dumb criminal of the day. Now, police responded yesterday to a domestic battery in St. Petersburg, Florida. According to police reports, the defendant threw a diaper at the victim, striking him in the center of the torso, and the diaper contained urine and other feces. Now, police say the confrontation began when Damian Caston began arguing with his brother about an ongoing domestic dispute. Caston, according to police, is paralyzed, but he's ambulatory by using his upper body. Now, after Caston damaged walls inside the home, he allegedly became aggressive towards his sibling and a witness and attempted to throw items at those people. At that point, Caston's brother and the witness lifted and carried the defendant outside for the safety of all and then called 911. Now, Caston then allegedly removed his soiled diaper and threw it at his brother, striking him in the chest, of which remnants of the diaper were seen on the front of the porch and on the stomach of the victim. The weapon was seized by police. Anyway, charges have been made against Mr. Caston, and he was booked into the county jail, released on his own recognizance. He obviously cannot have any contact with his brother, which means now go home to the house, except for his one civil assist where he can retrieve his personal belongings. I'm sure that will also include a box of diapers. All right, that's all we have for you today, ladies and gentlemen. Thanks for watching. We'll see you next time. I'm going to take the weekend and try to just relax. That's what I'm going to try to do. And work. Relax and work. But I'm over the whole Chad Daybell thing. I really am. Anyway, thanks for watching. We'll see you next time.